Learning Chapter 12, Residential Tenancy. In this chapter, we're going to explain the legal relationship between landlord and tenant, identify various changes in statutory requirements regarding residential tenancies with the Residential Tenancy Act, identify and describe four types of tenancies, discuss selected provisions contained in the Residential Tenancy Act, as well as exemptions provided under the Act, highlight selected provisions regarding mobile home parks, land lease communities. Summarize key points. Summarize key points um, about topics like entry by the landlord with or without notice, rent guidelines, tenant selection and termination by landlord and tenant, and apply the laws relating to our landlord and tenant relations in situations that may be encountered by the real estate practitioners. So let's go to the Residential Tenancies Act. Residential tenancies, the listing and sale of premises which are subject to residential tenancies present some special challenges to the real estate practitioner. Over the years, revisions to the landlord and tenant legislation have provided a reasonable degree of security of tenure for the residential tenants. Some areas of protection include the tenant's privacy limitations on the right of tenant to obtain vacant possession, right at procedures concerning subletting, landlord provisions concerning entry and termination requirements. The Resident Tenancy Act spells out procedures for termination of occupancy by the landlord or by tenants. There are a limited set of number of circumstances under which a landlord is entitled to terminate the tenure of a tenant. Rent control. The original Rent Control Act imposed a form of rent review on residential tenancy units in the province of Ontario. The concept of the act was that, subject to certain exemptions, rent could not be increased by more than a certain percentage each year. Landlords could apply for an increase above this amount if the increase could be justified and the proper procedures were followed. Originally, the rent control guidelines from a previous tenant applied to the new tenant after the previous tenant vacated. Current rent control guidelines are now embodied in other legislation do not apply to this situation. Of course, the guidelines apply to any subsequent increase for the new tenant only. Recent changes. The Landlord and Tenant Board is responsible for all matters regulated under the Tenancies Act. Units are not subject to rent control when first renting to the new tenant. Obviously, when they come up for renewal, rent control applies. Landlord must give new tenants a pamphlet to information on the responsibilities of the tenant and the landlord, the role of the landlord, the tenant board, and the contact details. This pamphlet is available through the landlord and the tenant board. Landlord can apply to the landlord and tenant board for any unjustifiable increase in rent by more than the rent control guidelines. If taxes or charges or utilities have increased, if utility costs or the taxes go down, the rent must go down. The rent increase application is for a capital expenditure or security services. There is a limit of 3% above the guidelines for a maximum of 3 years. Once the capital expenditure is fully paid for, the rent must go down for any tenant who are who were living there at the time of the increase. Like the previous legislation, the landlord may may show a unit to a prospective tenant between 8 a.m. and 8 p.m. without without the written notice. If a notice of termination has been given and the landlord informs the tenant and or makes a reasonable effort to inform the tenant of the intentions to show the unit. At a hearing of for the above guideline rental increase application, the board can decide to deny or delay the rent increase if there are serious outstanding maintenance issues or work orders. The rate of return, the rate of interest that the landlord must pay to the tenant on the last month's rent every year is the same as the annual rent increase guidelines, and the landlord can the interest use the interest to top up the last month rent to keep it current. So to recap, the rate of interest that a landlord must pay to a tenant on the last month rent and deposit every year is the same as the annual rent increase guidelines, and the landlord can use that interest to top off the last month rent to keep it current. The annual rent increase guidelines is based on the CPI, which is the rate of inflation. The landlord has a statutory right to show the rental property to a potential buyer with a written notice at least 24 hours in advance. The tenant flexibility to give as little as 10 days notice and move after receiving notice of termination from the landlord for demolition or conversion also applies to situations where the landlord personally requires the unit. The landlord has a has a statutory right to give notice on behalf of the buyer who personally requires the unit at the term of the tenancy. The 10 days option applies for the tenant receiving such a notice. The notice period for termination by the landlord for non-payment of rent is 14 days. To avoid eviction, the tenant must pay the arrears by the termination date, except for the notice of non-payment of rent. When a notice of termination has been served on the tenant, the landlord must apply to the board for an order terminating the agency not later than 30 days after the date specified on the notice of termination. This is a shorter eviction process for tenant who cause willful or excessive damage to the rental unit or the building. The shorter process also applies to tenants who cause disturbance in small rental units, whether it's landlord authorized. The notice period to the tenant is shortened to 10 days from 20 days. Landlords can apply to the board for an eviction notice immediately after serving the notice. Tenancy. There are four types of tenancies: fixed term, periodic term, tenancy at will, and tenancy at sufferance. A fixed term is the one in which the tenant has exclusive possession for the specific term, which is normally agreed to in the written contract. In a fixed term lease, both the commencement and the expiry date must be determined before the lease stays in effect. In a commercial fixed term tenancy, the tenancy ends on the expiry date and no notice is required. However, it is usual for the tenant to continue on a periodic basis. In resident tenancies, the tenant remains in possession of the property following the expiry date. The tenancy is deemed to continue on a month-to-month basis, pursuant to the Residential Tenancy Act. Periodic tenancy. Periodic tenancy is a tenancy for the fixed period, but a definite length that can be made certain by the notice of termination. In other words, the periodic tenancy automatically renews itself unless a notice is given to the contrary. In residential tenancies, a periodic tenancy can be either in writing or oral, or may simply state that the tenancy is on a month-to-month basis. The residential tenancy remains in a property following the expiration of the fixed-term tenancy. The tenancy relationship normally converts into a periodic tenancy automatically. Tenancy at will. Tenancy at will arises after the expiration of a lease or when no lease exists. The tenant remains in possession with the consent of the landlord or the person entitled to possession. Real estate practitioners should be aware that the tenancy agreement can occur by contract or by implication from the act of the parties. The implied tenancy at will may arise when the tenant occupies the premises without rent. The express tenancy at will may arise when the real estate transaction does not close on the scheduled date and the possession is granted in anticipation of a future closing. Tenancy at sufferance. This type of tenancy, also called overholding tenancy, occurs when the person has possession without the consent of the owner and without paying rent. It arises by implication of law in situations where tenancy has been terminated but the tenant does not vacate. Tenancy at sufferance might typically arise if the tenant does not vacate after the proper notice to quit and or did not vacate after the fixed term tenancy expired. In certain circumstances, the tenant may be liable for damage for the double rent. Once again, the decision overholding is subject to the Residential Tenancy Act. Resident Tenancy Act. The Resident Tenancy Act is a complex piece of legislation spanning numerous provisions that not only impact resident tenancy but also care homes and land lease properties. Selected common encountered topics are outlined. Residential Tenancy Agreement or standard form of lease. The Residential Tenancy Agreement is required for all residential tenancies entered after the Residential Tenancy Agreement or standard form of lease is required for all residential tenancies entered after April 30, 2018. This includes single and semi-detached houses, apartment buildings, condominium, and residential units. This agreement is not required for tenancy. These special tools are exempt under the Tenancy Act, such as a care home, mobile home parks, land lease communities, social or supportive housing. Abandon. The term abandoned is defined as the act of leaving a rental premises completely and finally. The RTA sets out provisions concerning the abandonment of the rental unit and the landlord rights concerning the disposal of tenant unit. The unit is not considered abandoned if the tenant is still paying rent. The landlord must proceed cautiously regarding a seemingly abandoned unit. A unit is not abandoned when the rent is paid. However, confusion can arise when the unit appears vacated and the rent is not paid. Substantial evidence must precede any action taken by the landlord. Clear evidence must exist that the tenant has left, that all possessions are gone, and the door is left open. Evidence must be cumulative in support of taking any action. Such evidence might include the fact that the tenant informed the landlord of his or her intent to leave. The mail has remained uncollected, and the neighbor spoke with the tenant and saw the residential unloading. Personal effect: the landlord should make attempts to contact the tenant, and at the minimum keep the record of such attempts. Notwithstanding these guidelines, any landlord can take on substantial risk by re-renting a unit or taking other action. Access: the right to access or gain admittance into rental unit is addressed in the RTA. Matters concerning access should be clearly understood by all salesperson. The landlord may not restrict reasonable access by election candidates or their authority representative for any federal, provincial, or municipal office. The landlord cannot change the entry locking system to residential unit without providing replacement keys to the tenant. The tenant can apply to the landlord and the tenant board for an order to regain possession of the unit if they have been illegally locked out. The tenant cannot change and have someone change the entry locking system to a residential unit without the landlord consent. Animals. Any provision in the tenancy agreement that forbids animals is a violation of the Act. In other words, no pet provision in tenancy agreement is void. However, exceptions do occur. That is provision in that Ontario Human Rights Code or pet provisions in the condominium. The condominium declaration may contain enforceable provision that no pet provisions relating to the occupation and the use of unit and the common elements. Practitioners commonly encounter questions regarding pet in rental accommodation. Any tenant or landlord wishing detailed information on or currently involved in a dispute concerning animals is strongly advised to contact the LTB. Landlord may make application for an order to terminate tenancy and evict the tenant under special circumstances concerning animals where the animal causes substantial interference to the reasonable enjoyment, causes a serious allergic reaction, and the animal is inherently dangerous. Assignment. Assignment provision apply to all tenants, whether periodic, fixed, contractual, or statutory, but not to the tenants of rental premises. If the tenant requests an assignment, the landlord can either consent or refuse the consent. If the landlord requests an assignment to a specific assignee, the landlord can consent or refuse consent based on that assignee. The refusal regarding the assignee cannot be arbitrary or unreasonable. It should be noted that the landlord may consent to an assignment subsequently refuse an assignment to a specific assignee. The landlord may charge reasonable out-of-pocket expenses in giving the consent. If the assignment is requested by the tenant and the landlord refuses or does not respond within 7 days, the tenant can give notice of termination within 30 days of the request. If an assignment is made, the terms and conditions of the tenancy agreement continue to apply. Both the assignee and the tenant, or the former tenant, are liable to the landlord and have rights under the tenancy agreement as follows: the former tenant for the period to the assignment, and the assignee for the period following the assignment. Various for the care homes, various matters concerning operation of the care home fall under the RTA. A care home is generally described in the residential complex. And it describes the residential complex in which residents receive care services, including healthcare or particularly elevated services, or services that assist with daily living activities. The regulation sets out the range of such services as a guideline, including nursing home assistance with bathing, feeding or dressing, ambulatory and personal hygiene assistance, and personal emergency response services. Practitioners do not commonly encounter situations involving care homes. A written tenancy agreement involving care home must be provided, setting out care services and meal, including including related costs. Every tenancy agreement must have the statement outlining the prospective tenant. A written agreement involving the care home must be provided, setting out the care services and the meal, including the related cost. Every tenancy must have a statement outlining the prospective tenants have the right to seek the third party may cancel the agreement within 5 days upon entering into it. Other tenancies contractors landlord can have a care related and non-related within the same residential complex. In such a instance, the former are referred to as the care attached units and the former the provision set out for the care homes. The information package must be provided to all the prospective tenants, setting out of the particular, including but not limited to the alternative packages or packages of care services, information regarding staff and emergency fire and medical response service systems. The regulations set out the minimum requirements concerning materials to provide the package. Not all rehabilitative therapeutics accommodation fall under the provision of the care homes. Condominium conversion. The RTA provides the tenant security of tenure in the event that a residential complex is converted into condominium. The landlord cannot demand the tenant move out in order to convert the rental building into condominium. The tenant, in most cases, can continue to live in the rental unit after the property becomes registered as a condominium. Entry right of the landlord. Entry with 24 hours written notice. A landlord can enter between 8 a.m. and 8 p.m. to carry out repairs or to do work in the rental unit, to allow potential mortgagee or insurers of the residential complex to view that particular unit, to allow the potential mortgagee to view the rental unit, to inspect the purpose of to inspect for the purpose of ensuring that the material property is in good state of repair and meet health, safety, housing, and maintenance standards consistent with the landlord obligation of any other reasonable reason specified in the tenancy agreement. Entry without written notice. Entry is permitted without written notice in the following situation: in case of emergency or tenant consents at the time of entry, if the tenancy agreement provides for regular cleaning by the landlord, and if entry is made at the time specified and between 8 a.m. and 8 p.m. when no times are specified. If the landlord wants to show a prospective tenant, and if the landlord and tenant have agreed to a termination or either has given the notice of termination, the landlord enters the rental unit between 8 a.m. and 8 p.m. and the landlord before entering makes reasonable effort to inform the tenant of his or her intention to enter. Exemptions. Various rental agreements are specifically exempted. Various rental situations are specifically exempted under the Act. For example, accommodation for traveling and vacationing public, seasonal or temporary accommodation, farm employee whose occupancy is conditional on the continued employment, non-profit housing cooperatives, penal or correction facilities, accommodation that are subject to selected acts, for example, Public Hospital Act, Private Hospital Acts, Community Psychiatric Hospital Act, Mental Hospital Act, Home for Age and Rest Home Act, Nursing Home Act, Ministry of Correctional Services Act, Charitable Institution Act, Child and Family Services Act, Emergency Shelter, accommodation provided to students by the education institution under specific circumstances, and employee with accommodation in the same building or project used in part or in whole for a non-residential purpose, and accommodation is contingent on continuing employment. Occupant sharing bathroom and kitchen facility with the owner's spouse or same-sex partner, child, parent, or spouse of same-sex partner, child, parent. Premises occupied by for business and agricultural purposes, available living accommodation, attached and under one lease accommodation involving a rehabilitative therapeutic services subject to certain restrictions. Mobile home park and land lease communities. A mobile home park or land lease communities is a community in which the landlord retains possession of the land, structures and services and facilities for the common use and the enjoyment of the tenant. The land lease home is a permanent structure as opposed to the mobile home. For the purpose of the Act, the term mobile home parks and the land lease community are used interchangeably. Practitioners are increasingly involved with mobile and land lease home as a consequence of the aging Canadian population and certain pricing advantage that are associated with land leases. A summary is a tenant has the right to sell or lease the mobile home or the land lease home without the landlord consent. Any agreement that requires the tenant to use the landlord as the agent is void. The landlord may act as an agent for the tenant. A negotiation for the lease or sale of the mobile home and or the land lease home with the written agency contract for the purpose of beginning those negotiations. The tenant in selling his or her mobile or land lease home may place a sign in the window of the home unless prohibited by the landlord. The landlord can only prevent such a signage if all of the following conditions are met. The landlord provision regarding the sign applies to all the tenants. The, the landlord provides a bulletin board for placement of for sale advertisement. The bulletin was provided to all tenants and free of charge and located in a permanent place accessible to public at all times. The Resident Tenancy Act provides that no charge of rent or increase of rent is allowed given that lawful rent given lawful and permitted. Lawful rent for a new tenant is the new rent charged to that new tenant subject to certain qualifications outlined in the Act. The topic of lawful rent has understandable complexities as a general statement. The landlord can only increase the rent in accordance with the Act if 12 months have elapsed since the rent increase and the last day the rental unit was first rented by the tenant. Special provisions apply to the existing tenant previously falling under the Rent Control Act. The following are selected points regarding the increases. The landlord must give at least 90 days notice on the approved form for rent increase. They must include an increase involving higher operating. This includes increase involving higher operating expense or capital expenditure. An increase is void if the notice not provided in accordance with the Act. No landlord can increase the rent more than the guidelines, except in accordance with the Act. And added costs relating to the addition of a parking space or a prescribed service facility or privilege accommodation or either agreed on to the tenant by the landlord is not deemed to be an increase for the purpose of rent increase under the Act. Parking or prescribed services are no longer provided. The rent must be reduced accordingly. Rent deposit. The rent deposit cannot be more than the less of the amount of rent for one rental period or 1 month. Any reference to the rent security deposit is automatically deemed to be a rent deposit for the purpose of the Act, and maximum rent deposit is a 1 month's rent. If the lawful rent increases, the landlord may require the tenant to pay the appropriate additional amount concerning the rent deposit. If the tenant is required to pay the tenant interest annually on the rent deposit, the landlord is required to pay tenant interest annually on the deposit. Such interest is calculated as a percentage increase from year to year in the CPI for the price of the goods and services as reported monthly by the Census Canada, averaging over 12 months period at the end of May of the previous year, rounded to the first decimal point. The rent increase is applied to the last rent period prior to the termination of the rent. The rent increase is applied to the last month to the termination of the tenancy. The tenant is not required to provide landlord with a posted check or agree to automatic debit payment for an account from an account or to credit card or similar automatic withdrawal for rent payment. Any landlord stipulation to that effect tenancy is a violation of the Act. Landlord must provide receipt relating to rent and rent deposits upon request by the tenant. Rent guidelines. Increase in rent are not permitted for a tenant or assignee except in accordance with the Act. With regards to subletting provisions apply to all tenants, whether periodic, fixed, contractual, or statutory. The Act sets out various requirements and restrictions concerning subletting. Selected items are highlighted for descriptive purposes only. Subletting provisions do not apply to a tenant or for subtenant premises. The landlord cannot arbitrarily or unreasonably withhold consent to sublet. Tenant selection. Section Regulation 290/98 under Ontario Human Rights Code sets out permissible landlord practices including tenant credit references and rental history information. A landlord may request credit references and or his rental information, authorization to conduct a credit check, and a guarantee for the rent, in addition to the rent deposit in order to access a subsequent select or refuse the tenant. Landlord may request income information if Only the item detail above, credit references and history are also requested. If such details are obtained, income information must be used in conjunction with the information to access and subsequently select or refuse a tenant. If such details are requested but not obtained, the income information can be considered on its own merit. If such details are obtained, information must be used in conjunction with the information to assess and selectively select or refuse the tenant. If such details are requested but not obtained, the income information can be considered on its own merit for selecting and refusing a prospective tenant. The final provision under this Act remains points that nothing in the regulation authorizes a person to refuse accommodation on the basis of race, ancestry, place of origin, color, ethnicity, citizenship, creed, sex, sexual orientation, age, marital status, family status, handicap, and receive political assistance. Termination. Termination by tenancy agreement is only possible in accordance with the Act. So termination before the end of the period. Reasons for termination include non-payment of rent, termination for cause, illegal act, misrepresentation of income, damage, interference with reasonable enjoyment of the tenants, impairing impairing of safety in too many persons occupying the rental unit. The act can also authorize termination for the repeat of selected causes. A change in the RTA from the previous act is a particularly note. A shorter notice period is now prescribed to landlords in the case of tenant who cause welfare or excessive damage to the currently owned building. The notice period reduced from 20 to 10 days also applies when the tenant causes disturbance in the small rental building where the landlord also resides. Now, at the end of the term, for the demolition, the notice period is 120 days. When a possession is required, it is 60 days. And when the sale of a property as well, there's 60 days if it contains more than 3 residential units. And for other reasons could be like the tenant fails to pay rent on due basis qualifications and the tenant ceases to meet qualifications and such things. With this, I think we are good. Thanks for your time.